Yes, hi everyone. During this session, I'm going to talk about the effects, the consequences of evidence that has been obtained as a result of an illegal search and seizure in the United Kingdom of England and Wales. The first point, the first place to start from, is that in principle, the in criminal proceedings, the law of England and Wales states basically that all evidence is admissible as long as it's basically relevant to the offense that the accused is accused for. So, um, therefore, in an offense of drugs, the drugs themselves are going to be admissible evidence since they are relevant, or in an offense of drug trafficking, gun trafficking, the guns and the uh, any other weapons found are going to be admissible evidence in that court of law, since if they are, well, because they are more likely to be relevant to the offenses, the related offenses. Um, However, not all evidence is always admissible. I mean, of course, it is relevant. Of course, when it's relevant, it is admissible. But the law in the law basically limits the extent. The extent strictly basically limits the extent of some relevant evidence to be admitted of relevant admissible evidence when there has been some kind of an abuse of process, which either compromises the quality of that evidence. So the court cannot no court can rely on that evidence because it may reach an unsafe verdict, and that would go against the doctrine of the presumption of innocence. And secondly, when evidence has been obtained in such a way that its consequences, even though no matter, I mean, even though it's relevant to the offense charged and the offense that the accused is accused for, the evidence hearing renders a trial unfair, and it constitutes evidence that has been obtained in bad faith and constitutes an abuse of process. However, not always has evidence that has been unfairly obtained had an unfairness on the proceedings themselves. The legal regime responsible for the for determining whether such evidence is admissible or not to a certain extent, coupled with common law principles, is the Police and Criminal Evidence Act 1984, which states, and especially Section 78, which Section 78 gives a fair amount of discretion to a court to rule out evidence that it considers to be unreliable, or either an abusive process, or either obtained in bad faith, and therefore undermining for example, the right of privacy to the accused. um, well, with regards to search and seizure, a policeman can the police basically can enter someone's house after having obtained a warrant of arrest, and after having reasonable grounds that the person for believing that the person that they are about to arrest is in the house, only then they can legitimately enter the house and search its premises. Um, let's say, and that is basically Section 17 of the Police and Criminal Evidence Act 1984. That's entitled "Entry for Purpose of Arrest." Um, let's say, for example, in the hypothetical scenario that the police did not have reasonable grounds for believing that the accused was there. Therefore, the arrest, um, the entry in the house is going to be unauthorized, and the fact that they did not have a, say along the fact that they didn't have a warrant in the first place, will render the evidence. I mean, the evidence is going to be, if they search his house and they find any evidence that implicates him in any sort of offense. This evidence, no matter if it's no matter if it's relevant to that offense that he's going to be charged with, um, and accused of, is not going to be, is going to be ruled out by the court as being unfairly obtained, as being obtained in bad faith, because in such a case the police, uh, not only they didn't have a warrant, but they didn't have reasonable grounds for believing that the person was in the house in the first place. So um, there goes their excuse for entering the house. Um, so they can't really enter the house, and therefore they can't search the house. It's a flagrant illegality and a terrible breach, an outright breach of someone's privacy, and the courts are likely not to take that lightheartedly. Um, so and therefore they're not going to admit that as an evidence in a court of law. Then the accused, of course, is going to have a very tactical advantage in his trial. Also, according to section 18, um, the uh, the police, according to the Police and Criminal Evidence Act 1994, they have they can enter and search without a search warrant after an arrest, and that's section 18, which basically states that a constable may enter and search any premises occupied or controlled by a person who is under arrest for an indictable offense. So the offense has to be an indictable one. If he has reasonable grounds for suspecting that there is on the premises evidence other than the items to legal privilege that relates either to that offense or to some other indictable offense, which is connected with or is similar to that offense. What needs to be understood here is that the constable has to have, again, reasonable grounds for suspecting that there is on the premises evidence that, well, other than evident items subject to legal privilege, of course, that this evidence basically relates to that offense or to some other indictable offense, which is connected with or similar to that offense. So let's say that someone is getting arrested under the for the offense of drinking and driving, and according to section 18, well, he has been arrested on the spot, um, and according to section by the police, and according to section 18, the police decides to exercise the Article 18 of the Police and Criminal Evidence Act 1984, and in order to enter and search his house after arrest. And though they do not have reasonable grounds for suspecting that on his premises, I mean in his house, there's going to be evidence that either relates to the offense of drinking and driving, or either to some other offense that is connected with the offense of drinking and driving. Let's say that they illegally enter his house because they do not have the reasonable grounds demanded by section 18, subsection 1, and they do, in the course of the search, they discover that there are guns in the house. So they do charge the accused with gun trafficking offenses. Well, in this case, the question that is raised again is whether this evidence that is illegally obtained could be admissible in a court of law. Well, in principle, it is relevant to the offense, to the offenses for to the offenses of to the offenses that the offenses for the that the accused is charged for. However, again here the police has committed a flagrant illegality. It has breached the accused's rights to privacy. I can't see any way that um, I can't see any way that his right to privacy has a direct effect on uh, the his the proceedings of the trial of him being prejudiced in his trial. Um, but since the right to privacy is a very respectable right, and not only because it's respectable, but because the police in that hypothetical scenario has acted again with bad faith and total um, defiance of the law. They just decided to enter his house without any reason whatsoever. The Basically, common law has drawn a distinction, and it's more likely that under section 78 the of the Police and Criminal Evidence Act 1984, the evidence is um, going to be it's going to be excluded. It's Yes, section 78's exclusion of unfair evidence, which basically states that in any proceedings the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. Again, I can't see in what way it would have any adverse effect on the fairness of the proceedings. Um, but it says later on, subsection 2 states that nothing in this section shall prejudice any rule of law requiring court to exclude evidence. And this section shall not apply in the case of proceedings before a magistrate's court inquiring into an offense as examining justices. Um, so there is also case law that there's also case law that um, that supports the exclusion of evidence that has been obtained after an illegal search and seizure, after basically after an illegal search which was the product of either trickery or missile of the accuser or the authorities, and calls for that evidence to be excluded. Thanks very much for watching. This is Dimitris Koulafetis, and I hope you enjoyed it. I hope you found it informational, and I will see you on my next video.